I spoke to Mr. Dharan a while back, and he was extremely excited when I suggested PMLA as a subject. As we know, it's a hot subject, and there is a lot of literature, newspaper articles, etc., that are going around, doing the rounds very regularly, and there's a lot of information. But we sat together and we sort of brainstormed on how can we make something special for the professionals that are members of the Chamber of Tax Consultants, as well as other professionals who may be interested in knowing about the Prevention of Money Laundering Act, beyond just what is there in the act and what you see in the papers and what you may be practicing. So we thought that it would be an amazing idea to come up with something that would be aimed at professionals. And I thought up that we keep talking about PMLA and about how this is now economic offenses have taken on the forefront. From 2014, we've got a slew of legislations that have come in. All the old acts that were with respect to economic offenses have been amended and been made effective. We've got the Benami Act, we've got obviously the PMLA Act, we've got the Black Money Act. This government is extremely keen to ensure that the economic offenders are brought to book, and I think that is a great step in the right direction. Coming back to the Prevention of Money Laundering Act, we are all aware, I'd like to believe, on what the Prevention of Money Laundering Act is. Well, the act's title is, explains itself. It basically is an act that is for the prevention of money laundering. But just going beyond that, what does the Money Laundering Act mean for people like you and me, for chartered accountants, for advocates, for company secretaries, and other professionals that may be practicing in the legal or the quasi-legal or the accountancy professions? Does it pose any risk to us? What are our roles that we can take part in with respect to these proceedings when our clients receive these notices? Is it possible for us to receive any notices or summons, and can we be called upon to give evidence in a court of law or in front of a tribunal or in front of any authority? I'm sure these are burning questions that a lot of people have, and a lot of them are by and far not answered, simply because there is a gray area around the Prevention of Money Laundering Act. And the more I think about it, the more I think that this gray area is deliberate. This gray area is deliberate so that the act itself can be organic and grow and mold itself to scenarios that may not have been envisaged in say 2002 when this act was brought out for the first time, or even with subsequent amendments. Though the act is getting sharper, I like to joke around with my friends that these economic offenses laws are like a game of chore police that people used to play when they were kids. It is always a game of catch and catch up, because every time the law enforcement catches up with someone, the rules of the game are very often changed. Let me just take you all through the slide. Let's address the elephant in the room. Let's just get down directly to it. What is AML and why is it relevant? AML is anti-money laundering. Why the PMLA 2002? Is the PMLA Act 2002 in India actually as draconian as they bring it out to be? What opportunities does the AML legislation present to me or you professionally? Should my client be worried? And should I, as a professional, be worried? I think this pretty much sums up what I tried to describe a couple of minutes back. These are the broad themes that we'll be getting into in today's conversation, and I hope you all find it as informative and interesting as it was for me trying to put this presentation together. Well, what is AML and why is it relevant? We will cover this on a broader level and not go into details, because I am not that, a lot of people keep trying to bring the international framework in, and perhaps at the largest level, it is very important to know what the Financial Action Task Force is, or what are the FATF recommendations, and what the risk-based approach for accountants is. And very honestly, during my master's on when my module on PMLA was going on, we studied these in detail. But these are just broad guidelines, right? These are completely, these do not directly bind us. These are to be implemented through domestic legislation, and but they are interesting because they bring out the blueprint for how the PMLA Act will evolve in the future. Because as a part of the organize as a sovereign country, as a part of the global organizations, uh, it is very important for us to be up to date with what happens in FATF and put up a strong PMLA framework. Now, why exactly did PMLA rise to be such an important aspect? Uh, in two words, two themes would be the PMLA was extremely important, to curb two distinct activities. One was arms trafficking, and second was drugs trafficking. So a lot of it was found that a lot of organized crime, cartels, etc., funnel their money in, their illicit money in, which was mainly in cash. And this has been going on for times immemorial, for the last 50 years or more. Get cash in and integrate it back through a complicated process into the economy. Now, of course, the drug menace, the arms menace, human trafficking, these are issues that do not just pertain to one country, they pertain to a lot of countries. And therefore, there was a call for greater cooperation amongst countries to combat the menace of money laundering. And the PMLA Act 2002, because it is a domestic act, perhaps decided it's better to go one step ahead. So it has not confined itself to just drug money, arms money, or money with respect to human trafficking. But interestingly, these are extremely important scheduled offenses in the PMLA Act. What is more interesting is, you all might have noticed that I placed a lot of emphasis on drug money. The scheduled offenses, the punishment for PMLA normally is, up to 7 years. But there is a special category that is set aside for drug-related offenses under the NDPS Act. So for a scheduled offense under the NDPS Act, the PMLA, punishment can go up to 10 years. So they've carved out a special focus area for drug money in the PMLA Act, even in India, which leads further credence to the fact that PMLA in India is not just about the scheduled offense or cheating or corruption, but it is largely in tune with the global effort against the scourge of economic offenses that are cross-border in nature. Just quickly running through this, right? The FATF is a global money laundering and terrorist financing watchdog. The intergovernmental body sets international standards that aim to prevent those illegal activities and harm they cause to society. As a policy-making body, the FATF works to generate the necessary political will to bring about national legislative and regulatory reforms in these areas. Therefore, the FATF continuously works with governments to ensure that the AML policies are in place. Coming back to our domestic act, the Prevention of Money Laundering Act 2002. The act says that it is an act to prevent money laundering and to provide for confiscation of property derived from or involved in money laundering and for matters connected therewith or incidental thereto. It is being realized world over that money laundering poses a serious threat not only to financial systems but also to the integrity and sovereignty. We go back to the fact that a lot of terrorist financing happens through these illegitimate networks, including Hawala, which is a very South Asian, Indian subcontinent sort of a concept. The basic fundamental behind having such a strong law for prevention for money laundering, again, for the offense of money laundering, is to take away the reward associated with the laundering of money. It is very rare that a crime is committed for no gain or just for the heck of it. The idea is, if you take away the carrot at the end of the criminal activity, and if you come down upon the perpetrators of these actions with a stick, then crime itself will reduce, because the old saying is there that crime pays. So what if crime did not pay? So the Prevention of Money Laundering Act is there to try to establish that crime does not pay. Is the PMLA Act as draconian as they bring it out to be? I'm sure a lot of people already have, views on this, and I'm sure most of the people have, already discussed this with their friends. Is the act draconian? Is all the hula that we actually see around, uh, in the that we see around in the public space or the discourse, is the PMLA Act actually that bad? In one word, yes. Also, I will also be taking up certain questions that have been typed into the chat box, and I will be sort of organically trying to go in and out of it. So please do not feel offended if I take some time to get back to the question. Otherwise, these questions can always be taken in personally later. But I'm going to continue with the slideshow for now, and I will come back to the questions in a bit. So why exactly is PMLA so bad, and why should our clients be so scared of it, or should they not be scared of it? The most important part about PMLA is the offense is non-bailable in nature. This is a big deal because as professionals, a lot of us will be tax professionals because we are the chamber of tax consultants at the end of the day. So the Income Tax Act, all the offenses are bailable. It's very easy to get bail in it. Bail is granted to you as a matter of right. In the PMLA Act, however, bail cannot be got to you as a matter of right. In fact, there are the infamous twin conditions for bail that we will get into in due course. I see there's a question that is given by Mr. Shukedia about what is the conviction rate. I do not have the exact figures, but there seems to be a video doing the round recently by the Honorable MP Mahua Mitra, I believe, that she says that that there were only 10 convictions, I believe, that were in the last year in amongst all the new matters that have been put up. So the conviction rate for most offenses in India is low, but we have to keep in mind that the conviction rate in a particular year would not speak about the specific year. Criminal trials in India last for a while, so it could be a long time before they see their logical end. So have it necessarily wouldn't be apples to apples comparison. How has it curbed drug and arms trafficking is something that we'll have to pose to the government, but it is not just about that anymore, right? Mr. Goel's question I will come back to later, and as far as the fourth question,
Aditya,
also
we
I'll
can
come
take
back
the
to
questions at the end.
Yes, all right. So again, there are the infamous twin conditions of bail in PMLA. They're up on your screen. That point is there on your screen, and that is what makes PMLA really troublesome for our clients, because it is not that I can just demand bail as a matter of right, because the offense is not bailable. But even amongst non-bailable offenses, the burden on me to get bail is extremely high, because not only do I have to convince the judge that I have prima facie not committed the offense, but also I have to sort of put the judge into sort of force him to gaze into a crystal ball and try to get him to predict whether or not I may commit any other crime if I am granted bail, which according to me is quite a draconian sort of a twin condition. The twin conditions have sort of played a dance of their own. They were there, and then the Supreme Court struck them down. Justice Rohinton Nariman had sort of struck them down, saying that they were extremely draconian, and then they had been revived by a subsequent amendment, and the revival through a subsequent amendment has now been upheld by Justice Khanwilkar's judgment in the case of Vijay Chaudhary. So the twin conditions as of today are very strictly on the book, and all our clients need to be really worried about it, because you do not, as a matter of right, necessarily get a copy of the ECIR, which is equivalent to the FIR, on the first go when you are arrested. Therefore, trying to get bail is trying to fence with your, both your hands behind your back. It is also the reason why we see that, if we see the headlines, the people getting bail in PMLA often get it after a period of months or even year and a half or longer. This is because of, according to me, the twin conditions of bail. right? What is most interesting about the PMLA Act is that the PMLA proceedings can exact a heavier toll than the primary offenses. Section 419 of the CRPC, it's cheating by personation. Now, this is a scheduled offense. The punishment for cheating by personation is 3 years, and the offense is bailable. But if you actually look at the PMLA, PMLA, as far as the punishment is concerned, has only two categories of punishment: 7 years or 10 years. For the 10 years is for drug-related offenses. So there is a chance that the primary offense that is committed, the scheduled offense that is committed, can be a relatively minor offense, and the predicate offense, that is the money laundering offense, may actually have a bigger impact on your life. It could actually carry a higher punishment, and it could be non-bailable. And this incongruity was brought out to the notice of the Supreme Court when the issues were being discussed in Vijay Chaudhary. The Supreme Court has held that that is a matter of legislative policy, and that they would not want to interfere, directly into this sphere, and try to influence policy. How good, bad, or right, wrong, fair, unfair, we can't really get into right now, because, well, the issue has been settled by the Supreme Court. So unless something happens in the review petition, which the Supreme Court has agreed to hear in the case of Vijay Chaudhary, even this remains, and it is good law. Now, I think let us see, what the most interesting part for you and me could be. What opportunities does the AML legislation present to me, or, well, when I say me, you professionally? Well, the PMLA consists of multiple proceedings, and it has three distinct aspects. All of them have an active role of professionals. Civil proceedings, that is for attachment and confiscation of property. This would be, very common for both CAs and advocates. Both of them would be involved in this, because most of the money laundering offenses, because the offense is about money, of course, there would be an accountancy aspect to it. There would be a part of compliance aspect to it, and there would be a strategy planning, that is always done in every transaction. And therefore, both CAs, lawyers, company secretaries, all of them could take part in the civil proceedings. Criminal proceedings go on before the special court for the offense of money laundering. The special court, well, is an exclusive domain of the lawyers. But again, a chartered accountant is extremely important in it. A company secretary is extremely important on it, depending upon the nature of the offense. Also, there's a good chance that a fellow professional like you and me may be called upon to give evidence in a court of law with respect to both civil and criminal proceedings when it comes to the doings of our clients. The compliance aspect is very often overlooked, because right from section 11, I believe, there is a lot of compliance that the financial intermediaries have to go through with respect to reporting entities. They're from section 11A. So reporting entity is supposed to comply with certain aspects of the law, because the PMLA Act is not only to punish political vendetta, but it is also there to identify and prevent money laundering. As we go back to the to the slide earlier, where we said that the AML framework is not only to punish those who have indulged in PMLA, but also there to make sure that the offense of money laundering doesn't really happen. The compliance aspect is extremely important. Also, it is something very interesting for chartered accountants, lawyers, etc., to get into, because there is quite a bit of compliance that is involved for reporting entities. This could include banks, NBFCs, and all other reporting entities that are notified. So this is a very interesting and often overlooked aspect of what opportunities the AML framework holds for professionals. If you all are thinking I'm going too fast, too slow, please, you all can drop a message in the chat box, and I'll try to adjust my speed accordingly. Sorry. Should my client be worried? I'm sure we all have our opinions on this. Very honestly, the PMLA Act is, very widely worded. It is deliberate, and it is widely worded because, as I discussed, they do not want the PMLA Act to be restrictive. The PMLA Act is supposed to function with with the needs of the time, right? We have over the last few years seen so many different financial models, so much structuring that goes on, that chartered accountants, company secretaries, income tax professionals, GST professionals, or even lawyers indulge in trying, the company structures have become complex. Everything, even, there are trusts, there are charitable institutions, the business the business structures are not simple anymore, right? So the PMLA Act is, very wide, it casts a very wide net so that they can prosecute you or try to find you, and you do not slip away from the net that they have cast. um, the most worrying part about PML, according to me, is that originally, obviously, as I said, the concept of PMLA seemed to be that, the idea was that, we'll curb drug trafficking, we will curb, arms trade, we'll curb human trafficking, and we will punish those who are there. But then, with respect to, what has actually happened is that we have a large part of the CRPC, the Criminal Procedure Code, which is very general law, that is listed in a part of the schedule. Just a clarification here, because I may use these terms interchangeably. Very often when you read judgments or when you will listen to lectures, people will prefer to, the act of money laundering and a predicate offense. And sometimes they use the word scheduled offense. Now, usually the predicate offense would be the primary offense that has been committed, which has then led to the prevention of money laundering PMLA proceedings being initiated. But, in my opinion, I usually prefer looking at the offense under CRPC or under the NDPS Act as the primary offense. And I usually refer to the PMLA Act as a predicate offense because it is not the primary offense. The predicate offense, that is PMLA, is extremely dependent on the existence of a primary offense. If there is no scheduled offense, then there can be no PMLA proceedings. So, very often I will use the word predicate offense for PMLA and the primary offense for the scheduled offenses. If an offense is there in the schedule to the PMLA, then it is called a scheduled offense. And it is only upon the occurrence of those offenses that PMLA proceedings can be initiated. What is extremely important to our clients is their personal liberty. I mean, you will have noticed very often that clients are extremely open when it comes to financial penalty. They're like, "Bhai, jo hoga dekh lenge." That sort of, they have that sort of attitude toward things that may have only a monetary penalty attached to it. But when you actually consider the fact that there is a chance that you may go to jail, and you may again go to jail for 7 years, and getting getting bail would be next to impossible for quite a period of time. Suddenly, even the clients get on, guard. And the problem is, I will liken PMLA to quicksand, right? Once you step in, there's a good chance that you'll be sucked down completely. Your life will not be the same by the time you come out at the other side. There is attachment, there is confiscation of property, there could be freezing of funds, there is obviously the regular arrest bail provisions that are going on, and there would be the scheduled offense that you'll be trying. We are talking about multiple proceedings out here, and very honestly, we all know that having just one proceeding in income tax or one civil suit or a criminal case going on against you, it affects your business and your life quite strongly. So the PMLA Act is a vortex. It is it is a center of the storm when it comes to disrupting business activity, which is what a lot of speakers have been saying, to the newspaper, that the use of the PMLA can be perhaps a very strong disincentive to foreign investments and entities coming into India. The same thing that went for GST also goes for PMLA if your client is a financial intermediary or a reporting entity, because then the AML legislation adds to the compliance burden of these organizations. But, well, it's good for the professionals, because obviously professionals have to ensure that the clients stay within those four corners of the of the compliance that has been put on. We will also briefly go through the compliances, and that should give us a better idea of how, what exactly is the compliance all about, and it'll give us a better idea of why it is there and how the government can use it. Should I, as a professional, be worried? Well, chartered accountants and lawyers are both privy to sensitive information. We may receive summons during investigation. In fact, we will be dealing with a case where a very prominent lawyer, you all may have heard of her, received summons for giving evidence in a PMLA proceedings, and she had moved the Madras High Court in a writ petition, but the Madras High Court at that point of time had not given any relief. Lawyers have an advantage because they have a thing called immunity, client confidentiality, privilege. Chartered accountants do not have that privilege. Company secretaries may not have that privilege. Also, a lot of them, company secretary may be more involved with the day-to-day running, with the people that are into the day-to-day running of the company. So there are obviously more significant risk factors for CAs and CSs as compared to another professionals, as compared to just lawyers that may be just working on a assignment rather than on a retainership. Of course, this would not extend to lawyers that are there on a retainership or those who are not considered an active practice, because lawyers are not allowed to be employed. However, a lot of lawyers do choose to go in-house. We'll be getting back to that in a bit. Again, chartered accountants, lawyers, and CSs may find themselves certifying documents or statements. I mean, I'm assuming there are quite a few chartered accountants in the audience today, and chartered accountants, if nothing else, very often have to certify the audited financials of a company. They do issue a lot of certificates for the purpose of income tax, for the purposes of GST. Now, these certificates can both be used, misused. The data that, that a chartered accountant is usually at the mercy of their client when it comes to collecting the data. You go to the client and you ask for data. Now, there is no way a chartered accountant can be completely clear whether the data that is being supplied to him or her is genuine or not. And that is where the problem happens. What if you certify, what if you issue a certificate on data that is, the figures of which are fudged? And that is a very real risk factor for both CAs, lawyers. Panel advocates very often certify, legal documents, legal due diligences happen. Loans are extended based on, certain norms. So all these aspects, wherever certificates are being issued, etc., where documents are being scrutinized, professionals are open to proceedings under the Act. Let's just get into what the offense of money laundering is, right? Now, we'll read this very deliberately because I believe that, there is no way to have a conversation on money laundering without defining money laundering. So the definition is: whosoever directly or indirectly attempts to indulge, or knowingly assists, or knowingly is a party, or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted property, shall be guilty of offense of money laundering. For the removal of doubts, it is hereby clarified that a person shall be guilty of offense of money laundering if such a person is found to have directly or indirectly attempted to indulge, or knowingly assisted, or knowingly is a party, or is actually involved in one or more following processes or activities connected with the proceeds of crime, namely concealment, possession, acquisition, or use, or projecting as untainted property, or claiming as untainted property in any manner whatsoever. The process or activity connected with proceeds of crime is a continuing activity and continues till such a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use, or projecting it as untainted property, or claiming it as untainted property in any manner whatsoever. It is an extremely complicated definition, according to me, because it is meant to be as open as possible. But there are recurring themes, such as the word projecting is, possession, acquisition, and proceeds of crime are repeated very often. And obviously, projecting, claiming as untainted property is also brought into prominence. The basic idea is that if there is any transaction that is connected to proceeds of crime, there's a good chance that this definition can be used to claim that you have indulged in the offense of money laundering. Whether it is proved or not, what actually happens of the proceedings at a later point is another story altogether. But this definition, if we actually go through this slowly, and we as lawyers and CAs and other professionals, we are a creative bunch. So are the officers of ED. So it's extremely highly possible that if someone needs, if they want someone to be dragged into the four corners of this definition of money laundering, the good chance that they will be able to do so, because the definition is extremely wide. Now, the schedule of offenses. There were certain questions, there are certain answers, and there were certain thoughts that were put onto as far as the schedule of offenses are concerned. And we have IPC, NDPS, explosive substances, UAPA, arms, wildlife protection, again, right out there, Immoral Traffic Prevention Act, Prevention of Corruption Act, Explosives Act, Antiques and Arts Treasures Act, Customs Act, bonded labor, child labor, juvenile justice, immigration, passports, foreigners, copyrights, trademarks. Copyrights, trademarks are, also a part of the schedule of offenses. So there are certain offenses in the Copyrights Act and Trademarks Act that can give rise to PMLA proceedings against you. Biological diversity, protection of plant varieties and farmers' rights, Environmental Protection Act, Water Air Pollution Control, unlawful acts against safety of maritime navigation and fixed platforms on continental shelves, etc. It's quite wide. So, when we just think about the issue, about how it started off as, let's attack drug money, or let's attack arms trafficking. We've gone way beyond that. Also, we may be well aware that, IPC and Prevention of Corruption Act are two of the favorite predicate offenses, primary offenses that lead to money laundering proceedings. Most of the public servants that are charged, most of the politicians that are charged with the offense of money laundering are usually charged under offenses with IPC or Prevention of Corruption Act. The latter is obviously, more used. Interestingly, for professionals, obviously, there are certain acts under the SEBI Act, under the Companies Act, more specifically with respect to fraud, which again, a lot of chartered accountants, lawyers, etc., may be open to. A lot of directors, shareholders, everyone, right? They're very, very broad offenses. And the Information Technology Act, that is breach of confidentiality and privacy, like very recently there was a story on the deep web that a lot of data, customers' data from certain entities had been stolen, hacked into, and were sold. Now, not only would they be prosecuted under the regular law and the Information Technology Act, but the Prevention of Money Laundering Act could also be invoked against them. Coming to the interesting definition of proceeds of crime, this is luckily a lot less confusing than the definition of offenses of money laundering. It says, proceeds of crime means any property derived or obtained directly or indirectly, leaves nothing to chance, by any person as a result of criminal activity relating to a scheduled offense, or the value of any such property, or where such property is taken or held outside the country, then the property equivalent of the value held within the country or abroad. This last part, which is there in the box bracket, now courts have also held that it doesn't necessarily need to be, the value equivalent doesn't necessarily need to mean that it can be invoked only when the property is taken or held outside the country, though the act says so. But the aspect of property equivalent has also been, stretched to say that even property within India, if it is, if the proceeds of crime are not traceable, then the equivalent value, property of equivalent value held within the country can also be considered proceeds of crime. And this can be quite worrying for a lot of people. Going into the explanation, for the removal of doubts, it is hereby clarified that proceeds of crime include property not only derived or obtained from the scheduled offense, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity related to the scheduled offense. So direct, indirect is very important. So it's not like I have to directly benefit from a crime. We'll be getting into a case study where we'll observe whether a lawyer's fees or a CA's fees, whether audit fees could be considered as proceeds of crime if your client is accused of indulging in activities that may be punishable under the PMLA Act, right? So if your client earns money by committing a scheduled offense and PMLA proceedings are initiated against the said client, and if you've received fees, could those fees be attached? That is something also that we'll be exploring in this session. What is the punishment for money laundering? I think I've gone on it again and again. Rigorous imprisonment, hard labor, which shall not be less than 3 years, but which may extend to 7 years and also be liable to fine. This is for regular offenses. And then there is a proviso that says when the proceeds of crime involved in money laundering relate to any offense specified under the NDPS Act, the provisions of this section shall have effect, as if for the words which may extend to 7 years, the words which may extend to 10 years has been substituted. So again, drug money, 10 years. Every other offense between 3 to 7 years. There are judgments with respect to the twin condition that we'll get into, which says there is a concept that bail can be granted if a substantial portion of the sentence is already served. Considering that the minimum sentence that can be given is 3 years, then despite the twin conditions, your chances of getting bail increase a lot after 1.5 years. And if we actually do a little bit of thinking around randomly, very often the high profile cases that we've seen, a lot of people have spent substantial time behind the bars for between 1 year to 2 years, and a lot of them have got bail after that. Manuji, I'll be replying to your question later. Institutional framework, agencies. This is extremely important. Whenever the word PMLA comes up, we automatically rush to enforcement directorate. For all those who've practiced FEMA, they're already well acquainted with the ED. And now whoever was left, whoever didn't know the ED now knows it because of PMLA. I will not be spending a lot of time explaining it. It's already there. Now, policy issues regarding to PMLA are not under the ambit of ED. However, the lesser known entity is the Financial Intelligence Unit. This is for receiving, processing, analyzing, and disseminating information related to suspicious financial transactions. So the ED enforces the law, while, according to simplified, FIU looks after the compliance. It is an intelligence agency to gather intelligence with respect to possible economic offenses and money laundering activities. So we often look at the ED as the arm of the government, but FIU is working in the background, getting financial institutions to identify suspicious transactions so that these can be then acted upon. And I'm sure with all the data sharing that is going on, that the government is batting for greater coordination between the agencies, that the data is finding its way around as far as law enforcement and the statutory framework is concerned. Let's go to the Financial Intelligence Unit first. It collects, analyzes, shares information, and then also acts as a central repository, conducts research and analysis, and coordinates a lot of actions under it. And what it actually does, so my LLM was, my dissertation was in an AML activities, that was in anti-money laundering laws. And we had an entire session dedicated only to STR, suspicious transaction reports. This is the primary intelligence gathering activity that is carried on by reporting entities, where there are certain entities like financial institutions that are obligated to report certain transactions to to the central government or to FIUIND, which then processes it. We have a lot of banks that's why asking for KYC. We have a lot of banks that give you a call when an activity happens that is not normal. Suppose there is a large deposit that comes out of nowhere. There's a large withdrawal that comes out of nowhere. Also, these activities, these STRs are shared with the central government. Practitioners of income tax will know that, especially with all with the formalization of the economy, with the cash economy comparatively shrinking, that these STRs have become a very powerful tool, and they have also added substantially to the compliance burdens of the reporting entities. I hope I'm being clear. If for whatever reason I am not, or I'm going too soon, please let me know on the chat, in the chat box. Reporting entities have to maintain records. The reason why we are going into the reporting is because I believe that we do not go often into it. Compliance is an extremely important aspect of AML. In fact, there are a lot of jobs abroad, not just in India, but even abroad, in a lot of could be tax havens or central financial nerve centers of the world, like say London, etc., where there are entire teams and entire departments that are kept only for AML compliances, and that had been identified as a growing area even 10 years back, and it still occupies center stage. The chances of prosecutions, etc., the opportunities that prosecutions or attachment proceedings give to professionals are fairly limited. But I think if you look into the compliance aspect of it, it is fairly good work, and a lot of banks hire AML experts. A lot of cross-border international law is also involved in this, because a lot of these reporting entities also have branches in other countries, and a lot of the money flows in and out of, now because of digitalization, flows in and out of country borders quite easily. A reporting entity means a banking company, financial institution, intermediary, or a person carrying out a designated business or profession. These entities need to maintain a record, furnish to the director, not of ED, but FIUIND, information within the time prescribed, whether attempted or executed, and maintain records of documents for a certain period of time, evidencing identity of its clients, etc. So it's basically client audit. They also have to grant FIUIND access to information. They may ask the director of FIUIND may call for reporting entity, call from the reporting entity any of the records or additional information that are considered necessary for him with respect to PMLA, and they will have to be given within such time in such manner as the director may specify. Like nowadays, when we get the notice under Income Tax Act, also the faceless assessment center wants us to send data on scrutiny notices in specific formats. Well, I think it's not just the department. The whole thing is moving in that direction. Interestingly, a lot of people may or may not know this. Well, the ED definitely comes under Ministry of Finance, but then so do the authorities under the NDPS Act. So they all are under the control. Mainly the parent ministry is the Ministry of Finance. Save as otherwise provided for any law for any time being enforced, every information sought by the director shall be kept confidential. Obviously, FIU does not want you tipping off your customer that the data has been given to the director of FIU. The director may, on his own motion or on application, make inquiry or cause such inquiry to be made as he thinks fit to be necessary with regards to obligation of the reporting entity. At any stage, the director, if he wants it, will ask the reporting entity to get its records audited by a chartered accountant from amongst a panel of accountants maintained by the central government for this purpose. Well, again, as I said, there are a lot of opportunities that are there in the compliance section for young professionals. Uh, the director has the power to impose fines. The director also has the power not to impose a fine. Luckily, I haven't come across any jail sentence with respect to this. A lot of it is, if is mainly revolving around fines, which only with respect to FIU is concerned. So, if a director finds that a reporting entity or designated director on the board or employees fail to comply with obligation in this chapter, then he may issue a warning in writing, direct the reporting entity to comply with specific instructions, direct the reporting entity to send reports at such interval as may be prescribed, or by order, impose a monetary penalty on such entity or its designated director on the board or any of its employees, which shall not be less than 10,000 rupees, but may extend to 1 lakh for each failure. And save as otherwise provided in section 13, the reporting entity, its directors and employees shall not be liable to any civil or criminal proceedings against them for furnishing the information under the clause B of subsection 1 of section 12. Again, this slide makes it very clear that most of the penalties that are put are civil in nature. They're in the form of a fine. But there is a chance that if at all the enforcement director thinks that you are hand in glove with the client with respect to doing, the commission of the offense, there's a good chance that the officers that are hand in glove with the customers for the offense of money laundering may be prosecuted for the offense of money laundering. Maintenance of records is a general slide. I'm sure it will be circulated to the audiences by the end. So, I will skip through this, but cash transactions, everything that is suspicious, forged notes, and collection services by the bill checks, etc. All of these, the records need to be maintained. And then obviously whenever the director calls upon them for information, those need to be given. The following information, the 4 points are the record. The record should contain the nature, amount, date, and parties to the transaction. It's enough to say that the procedure and manner of maintaining information is with respect to RBI and SEBI norms and the rules that have been framed in the regard for PMLA. For those who are interested in the compliance aspect, I strongly suggest that the Master Circular dated October 15th, 2019 be gone into. I will be skipping upon that. Now, coming to the interesting part, perhaps for what most people are here with respect to the actual offense of money laundering. So, I had gone, I started out explaining that there's a good chance that lawyers are open to a certain sense of, privilege, client privilege. All of us who've seen American shows with respect to lawyers, it could be Suits, it could be Boston Legal, it could be anything else. A lot of emphasis is placed on client legal privilege. Now, with respect to legal privilege in India, it is a part of the Evidence Act. Therefore, it's a rule of evidence. Section 126 of the Indian Evidence Act, which deals with professional communication, states, no barrister, attorney, pleader, or vakil shall at any time be permitted, unless with his client's express consent, to disclose any communication made to him in course and for the purposes of his employment, such barrister, pleader, attorney, or vakil, by or on behalf of his client, or to state the contents or condition of any document with which he has become acquainted in the course of and for the purpose of his professional employment, or to disclose any advice given to him to his client in course of and for the purpose of such employment, subject to certain conditions that laid down in the section. Now, these section 126 to 129 of the Indian Evidence Act, I believe, is perhaps the only place which actually spells out this client privilege for lawyers. However, this doesn't mean that summons cannot be issued to you. Even among lawyers, there are a lot of caveats when it comes to privileged communication. Like when a client comes to you and says, engages you and says that I have committed this act. You can no longer, this section of the Indian Evidence Act bars you from saying so in court. But you cannot, if a client comes up to you and says that tomorrow at such and such time I'm going to commit this crime, is this right or wrong, or should I do it this way or that way, you're obligated to report it. So the privilege is not absolute. There are certain rules that are around it. The other professionals do not enjoy such this thing, what do you call it, privileges. Sorry, there is one question, and it is with respect to compliance. That is the reason I'm just going back. The master circular is SEBI guidelines, so it's by SEBI, but there are RBI circulars also, and I can obviously circulate them later if required. We'll get to the case studies in a bit. So we've looked at the compliance aspect. Now let's look at the criminal proceedings. This is where the lawyers can take note. Criminal proceedings in a special court, designated special court, obviously are in the exclusive purview of lawyers. Only lawyers can be involved in actually arguing these matters out. However, other professionals will invariably be called upon to lead evidence in it or to help the lawyer in preparing the case. In case you're wondering what I'm talking about, other professionals, I am mainly talking about you chartered accountants in the audience. You all, have a lion's role to play as far as either supporting the prosecution or supporting the defense, because most of the evidence that will be led with respect to the financial crime, the financial aspect, is falling squarely within your purview. So there's a good chance that a lawyer will be trying to help you out in a special court someday. And I say this obviously in lighter vein, so please do not take any offense to it. Offense of PMLA is tried in the special court designated for this purpose. This special court usually is a court of sessions. In order to save time, the trial of compound offense, I've written that please do not consider this as a compoundable offense. Again, I said a predicate offense that others refer to as predicate offense, or what is more often known as a scheduled offense, may also be shifted to the special court if the ED makes an application. But only the ED can make this application. So the law provides that if the ED thinks that multiplicity of proceedings can be avoided by clubbing, two trials together. Clubbing is the wrong word. I'm sorry. In my book, I've written that clubbing of trials does not happen. But if the same court should try both the offenses, the scheduled offense as well as the PMLA offense, then the ED can ask for the trial of the scheduled offense to be transferred to the PMLA special court. Now, this can also be, though, even for those offenses that are usually carried out, that are usually prosecuted in the CBI special court. So very often we see offenses that relate to Prevention of Corruption Act are very often tried in CBI special court. So even offenses that are supposed to be tried in a special court, the ED may always pray that the offenses from the CBI special court may be transferred to the ED special court, the special court for PMLA, and that the trials go on simultaneously. This would be mainly to save time, energy, and prevent duplication of testimony, because it is not like if there is a case of, let's just take a case of cheating 420, where I have the most common case, beyond Corruption Act, is misappropriation of a bank's money. Well, I'm not a bank, but suppose I have lent some money to my good friend, someone from the audience here, we'll not take names. I have lent some money to them, and I have given it to them for a specific purpose. And if they divert it for some other purposes, right, that could be a case of cheating, very often a misappropriation of funds against the contract. So a lot of cases for 420, etc., are registered by the banks for such offense, right? We can see that these are the most common scams. Vijay Mallya has been accused of it. Everyone, a lot of the big defaulters have been accused of it, of taking a lot of loans from the bank, siphoning of the funds, diversion of funds. Now, a lot of the evidence in such cases these are already economic offenses. These are not body harm matters. So a lot of the testimonies would be connected because the Supreme Court has been kind enough to hold that even the commission of the offense is an activity that is related to the offense. So you can be accused of PMLA. Sorry, I will come back to that. But I'm sorry if it sounded confusing, but I will come back to that. But it is enough to note that the ED, if it wishes to, can get both these trials put in the same special court. Can you and I ask for it? Can our clients ask for it? No, they cannot. We could ask the ED to make an application, but the courts have held that you and I cannot ask for our trials to be combined together, no matter how much trouble it causes us. The ED can do it though. Section 46 of PMLA makes CRPC application to PMLA applicable to PMLA proceedings before the special court, save as provided by the Act. Just like prosecutions under GST, under Income Tax Act, under Benami Act, the criminal aspect of it, the criminal trial, which is carried on by the special court, always will attract the provisions of CRPC. And this will be, but PMLA as a special act will have an overriding power over the general clauses of CRPC. So CRPC will be applicable only to the extent that the PMLA Act does not diverge from it or does not explicitly override it. Special mention to the special court, because the special court not only looks at the conviction of the accused for a PMLA proceedings, but the special court also has to pass a final order as to confiscation of the property that has been attached by the ED, which we'll be getting to in just a bit. As per Section 8.5 of the PMLA. So Section 8 is with respect to adjudication. Once the adjudication is done and the attachment is confirmed, it is only the special court that can give the final order as to confiscation or release of property. May I just be excused for a minute? I just need a drink of water. I hope you all don't mind. I apologize for that. So we've been through the functioning of the special court. If there are any specific queries with respect to the special court, I'll be happy to take them on. Yes, the difference between scope of IPC and CRPC. CRPC is with respect to procedure and IPC is with respect to the substantive offenses. IPC lists down offenses, while CRPC is with respect to procedure that is then used to prosecute the offenders. This is putting it very simplistically, but the Indian Penal Code was a complete code for all the offenses, and the CRPC was a complete code for the procedure. Most income tax people, will be, very familiar with the saying that the Income Tax Act is a complete code by itself. Well, criminal law is obviously not. So let's get to the meat of the matter, because, we are now well into the time. Your client has received a provisional attachment notice, and your client is going all crazy because they've received a notice from the ED. Now, the first thing you need to do is tell your client not to panic. Most of the people, when they receive this provisional attachment notices, do end up panicking. The provisional attachment is like a symbolic attachment. No third-party rights can be created. However, the ED cannot come take physical possession of the property at this point. These points that are there on the screen, we'll be discussing them in detail, because we'll also be looking at what replies that are to be given in a show cause, or where should a writ be filed or should it not be filed. More importantly, no show cause notice is required to be issued for provisional attachment. Properties of third parties can be provisionally attached by the ED if these are suspected to be proceeds of crime, even if the party is a bona fide third party. The provisional attachment of property is not restricted in the hands of the accused alone. Very simple. My friend steals a bicycle and hands it to me, and then I sell it, and I receive a handsome sum of 5,000 rupees for it. Even without a deep investigation, if the link is established, if the ED is worried that I may alienate those 5,000 rupees or whatever I purchased out of those 5,000 rupees, the ED may provisionally attach it so that no third party right can be created on it. Or if those 5,000 rupees are in the bank account, then they can freeze that part of the bank account. Very importantly, there does not need to be a pre-registered scheduled offense for provisional attachment. It is not right to assume that the attachment of property under the second proviso as amended has no link with the scheduled offense, inasmuch Section 5(1) envisages that such an action can be initiated only on basis on material in possession of the authorized officer, indicative of any person being in possession of proceeds of crime. So just because no one has actually made any complaint with regards to a provisional attachment, if the ED feels that what you have in your possession is proceeds of crime, the ED is allowed to provisionally attach it and then go to the police station and make sure that action is taken against you for the scheduled offense. So it's a chicken and egg scenario. A lot of people keep thinking that there is no provision, there is no scheduled offense, therefore no PMLA action, but the ED can actually file a complaint against you if they believe that what you have in your possession is proceeds of crime. Most importantly, as the ED will not come and vacate you from your house or vacate you from your office premises or your client from your office premises, there is no need to worry. However, this does give rise to substantial difficulties when it comes to challenging these orders. More importantly, you do not get a say during provisional attachment, because if a show cause notice is not issued to you, then you cannot necessarily reply to the same. Again, it is not mandatory. But what is important is that with respect, the scheme of Section 5 of the Act, which is with respect to provisional attachment, then extends to Section 8 of the Act, which is with respect to adjudication. Now, when it comes to adjudication, things change a bit, because the ED then will file a complaint before the adjudicating authority and produce all the material before it. Now, this material will be furnished to you, whoever it is that is defending, that seeks to show that their property is not the proceeds of crime. That is when you will be able to mount up a proper defense. Reasons to believe were perhaps the most loved phrase for all chartered accountants and tax lawyers when it came to Section 148 of the Income Tax Act. So reasons to believe will feel instantly very familiar to every tax professional here. Section 5(8) with respect to adjudication, with respect to attachment and adjudication, 16, 17, 18 with respect to search, seizure, arrest, etc. Not arrest, sorry, search, seizure, etc. Other proceedings and survey require the existence of reasons to believe, and these reasons to believe need to be recorded in writing. The Delhi High Court has held that a mere mechanical recording that property is likely to be concealed, transferred, or dealt with would not meet the requirements of Section 5(1) of the Act. Then again, if the record, now normally, as tax professionals, we've seen if the reasons for recording have not been reasons for believing have not been recorded, very often the entire 148 proceedings originally used to be quashed. But what has happened that certain courts have held that just because reasons to reasons to believe have not been recorded in 5(1), that would not vitiate the proceedings completely. So while carrying on provisional attachment, the attaching authority did not record reasons to believe that the petitioner was in possession of any proceeds of crime, and that such proceeds of crime were likely to be concealed, transferred, which may frustrate any proceedings related to the confiscation of such proceeds as a mandatory requirement under Section 5(1) of the PMLA. The show cause notice under Section 8(1) was issued in a mechanical manner without application of mind and without forming any reason to believe that the noticee had committed an offense under Section 3 or was in possession. These errors were considered to be jurisdictional errors, and the adjudicating authority did not record any reason that the provisional attachment should continue. These are some of the very few cases where the high courts have interfered with respect to attachment. But the most important aspect that the High Court of Telangana held in this judgment at these issues are jurisdictional errors. Again, all those that who are that are used to Income Tax Act under 148, we have always raised grounds that the absence of reasons to believe are jurisdictional issues. So similarly, when it comes to PMLA, the absence of reasons to believe recorded in writing are not just an irregularity, procedural irregularity, but are actually jurisdictional errors. Now, the tribunal appellate tribunal for PMLA set aside an attachment officer where the directorate had not communicated any reasons to believe while passing the provisional attachment order by relying on the judgment of the Supreme Court in CB Gautam. Now, not only is it important to have reasons to believe, but these reasons to believe need to be in writing. Now, the absence of recording reasons to believe does not result in violation of constitutional right. Although the section provides for recording of reasons to believe by the authority, failure to record is a statutory infraction and same can be pleaded before adjudicating authority. This is what Madras High Court had to say about it in 2019. In such circumstances, non-recording of reasons by the authority initiating action under Section 5, that would be the ED, of the Money Laundering Act becomes curable. So they said that it doesn't matter whether reasons to believe are not recorded, are there, whether there's an absence of it or whether they're not put in writing, because the provisional attachment is provisional. It automatically lapses in 180 days. So it is only an irregularity, a statutory infraction, and the same can be pleaded before the adjudicating authority, right? So that is what the Madras High Court had to say. Now, what Guwahati High Court said that when the deputy director has reasons to believe that non-attachment of property may lead to frustration of any proceedings, if the said reasons were not recorded in writing, the provisional attachment order could be stayed in light of the condition precedent, and then they would allow the ED to make good the defect. So, operation successful, patient dead when it comes to professionals. But Vijay Madan Lal Chaudhary, the Supreme Court held that it is only upon recording satisfaction regarding the twin requirements referred to in subsection 1 of Section 5 can the authorized officer proceed to issue order of provisional attachment of such proceeds of crime. So Vijay Madan Lal Chaudhary, as read with this VANA-PIC ports, that's the Telangana High Court, perhaps can give you a good chance to challenge a provisional attachment order. Now, the provisional attachment order, there is no provision to challenge it anywhere, right? The matter moves on to adjudication when the complaint is filed by the ED. You and I cannot do anything about the provisional attachment order. The only choice we have is to go in writ, and we will come to the fact that writ courts have not historically encouraged such writs. Is being proceeds of crime enough for the provisional or final attachment of this property? This is a trick question, especially because when I read it out, I said enough for provisional attachment or final attachment. The conditions for provisional attachments are very different from final attachment. For provisional attachment, not only does an officer have to be satisfied that the property that he's seeking to attach is a property that is proceeds of crime, but that officer must also have come to a conclusion that if such provisional attachment is not made, then the person in whose possession that proceeds of crime is would be likely to conceal, transfer, or deal with such proceeds of crime to frustrate confiscation proceedings, right? So to frustrate confiscation proceedings under Chapter 3 of the Prevention of Money Laundering Act. Now, considering all this aspect, Section 5.1 has enough safeguards. Problem, of course, being challenging Section 5.1 orders in the High Court, getting the High Court to interfere is extremely difficult because anyways, by the time the High Court order comes, 180 days are already over and the matter has moved on to the stage of adjudication. So Vijay Madan Lal Chaudhary, again to the rescue, says that the property, there has to be a satisfaction that the property involved is just not just proceeds of crime, but also such non-attachment may frustrate the confiscation of proceedings under the Act. Every lawyer has this question whenever a new client comes to him for a new question. So, to writ or not to writ, that is the question. Well, the law is very clear on this when with respect to alternate and efficacious remedy. So, the existence of such alternate remedy weighs in on the mind of a constitutional court while entertaining a writ petition. So, you challenge a 5-1 order and they'll say, "Why are you coming to us?" Right? Please go before the adjudicating authority and show that they're not proceeds of crime. Alternatively, if you are challenging a 8-1 notice, they will say you have a statutory remedy in the form of going to the appellate tribunal. Why are you coming to us again? The appellate tribunal order is appealable to the High Court, and the High Court order obviously later on through SLP to the Supreme Court if you so wish to go. So there is a proper appellate procedure in place. That is why High Courts are not generally very happy to entertain such writs. However, that there is no absolute bar for the High Court to entertain such writs, right? So what happens is that if you can prove that the notice, again, as we do it in income tax or other allied laws, where we say that the notice is completely without jurisdiction, or is a violation, or if there are some violations of my fundamental rights or my constitutional rights, then of course it is always open to the High Court to enter into this question and answer it. But again, there are various case laws where High Courts have refused to interfere in provisional attachments. Like when it came to Allahabad High Court, they said that, what, a provisional attachment attachment order is like a show cause notice, and that a writ petition at the stage of show cause notice is not maintainable. And Madras High Court said attachment is only provisional. Bank could appear before the adjudicating authority and disprove the claim that money is attached would be proceeds of crime. Then, however, with respect to Delhi High Court, the Delhi High Court set aside the provisional attachment order as well as a complaint under Section 8, where a plain reading of the order for provisional attachment did not indicate that there is any material on basis of which authorized officers of ED could have possibly concluded that investments made by the petitioner were derived or obtained as a result of any criminal activity relating to a scheduled offense. This judgment is more of an exception rather than the norm. It would depend very strongly on the facts of the case and upon the inclination of the court that is to exercise its discretion into either entertaining the writ petition or not entertaining it. Again, I find it extremely odd because a provisional attachment order is not like a show cause notice. In my view, I disagree, humbly with the view that various courts have held, because a show cause notice does not violate any of my constitutional rights. However, by limiting my limiting my choice with respect to transferring a property, a provisional attachment order may not be prejudicing me, to an extent where they are depriving me of my property, but they are placing restrictions on my action, as opposed to a show cause which just asks me to show cause as to why a certain thing should be done or shouldn't be done. So again, there were the other high courts have held again and again that show cause notices do not affect the assessees much or the aggrieved parties much, so writ petition should not be entertained against a show cause notice. Yes, I'll get to that question. Yes, sorry. Now, the definition of proceeds of crime is extremely important. Your client has received a provisional attachment order, and there are only two things that you can do, right, to escape provisional attachment or attachment. A, you have to show, more importantly, that the things that are being attached, the property that is sought to be attached, are firstly not proceeds of crime, and then secondly, these are not in the danger of being alienated in a way that would frustrate any proceedings under the Act. So the definition of proceeds of crime is extremely important, because if the property that is attached does not fall within the four corners of the definition of proceeds of crime, then attachment cannot happen. In fact, Vijay Madan Lal Chaudhary says that the attachment under Section 5 must only be in respect of properties which appears to be proceeds of crime, and not all properties belonging to concerned person would eventually face the action of confiscation of proceeds of crime, including prosecution of offense of money laundering. I will take one of the questions that has popped up on my feed right now, because obviously it is pertinent at this point. So it is asked whether can property that was acquired before commission of scheduled offense be attached? Please explain. Now, I had taken you all through the definition of money laundering and proceeds of crime. Now, if you all remember the concept of value equivalent that I had explained. So technically, property that has been attained before the commission of proceeds of crime would not fall within the definition of proceeds of crime. I mean, that obviously makes no sense, given that the term is proceeds of crime, and property that has been obtained before cannot be proceeds. However, the definition also includes property of value equivalent. So though it is completely possible that property is obtained before the commission of the scheduled offense, if the ED does not, if the ED finds that you have already alienated the property, or that there isn't enough property to secure the amount of proceeds of crime, then they may consider attaching that property that has been obtained prior to the scheduled offense happening as value equivalent. Vijay Madan Lal Chaudhary gives an interesting example, I believe, of a car that may be used in the commission of a crime. Suppose I use a car to rob a bank. The car cannot be attached as proceeds of crime. But what if the robbers have spent all the money? And if the money is to be attached in my hand as the robber, then as value equivalent, of course, the car would come within the four corners of the definition of proceeds of crime. Where the attachment order specified the quantum of amounts attached, the High Court allowed petitioners to operate the bank accounts subject to maintaining a balance of money corresponding to the amounts attached. This is self-explanatory, because again, attachment proceedings are not meant to punish your clients. Attachment proceedings are meant to secure the proceeds of crime. So suppose property is attached, and of course, if I have a good case and I show that those properties are not proceeds of crime, and if I'm willing to put up enough money to cover the proceeds of crime, the amount of proceeds of crime, then the courts or the authorities may consider releasing the actual property. This is extremely important, because there are judgments that say that what can be attached is only proceeds of crime. Suppose I have obtained only 100 rupees as proceeds of crime. The ED cannot attach property worth rupees 1,000. They can attach only to the extent of rupees 100. Notice received by bank for attachment of a property mortgage to it. A lot of my fellow professionals may have clients that are banking companies. A lot of them may also have clients whom they hope are banking companies. So a lot of banking companies nowadays are getting show cause notices or section 5.1 notices or 8.1 notices for attachment of properties. Simple example, let's take the case of Kingfisher, right, where PMLA proceedings are taken out against the erstwhile promoter of Kingfisher. But PMLA proceedings would also be taken out against the person's properties, because they do not want that person to alienate it, right? However, most of those properties have already been mortgaged to banks, and the primary complainant in those cases are the banks, because the primary complaint is that monies have been diverted or siphoned off, etc. So there is a case where I am a bank, I have given monies to a person, that person's diverted it, I have a mortgage against the property, but when I move in to exercise my right as a mortgagee, the ED swoops in. So you know how they say between when two people fight, the third person takes the advantage. Well, that could have happened. However, luckily the courts have been very proactive, and they have protected bona fide third party purchasers and third party interest holders. unlike the Benami Act, there is no specific protection for innocent bona fide third party dealers when people dealing with possible proceeds of crime in the normal course of business in a bona fide manner. But the courts and the tribunals have read into it, and they have said that you cannot be punished for something that you have not done, especially with respect to banks, because it is focused again and again on the fact that bank money, financial institution money, is usually public money, and they have interestingly tried to distinguish a bank from the officers of the bank. So they're saying that if a bank has committed a certain offense, it is not the bank that has committed the offense, it is actually the manager of the bank or the person concerned in the bank who has actually sanctioned the loan in connivance with the person, etc., who has actually wronged the bank. And they say that the bank is the victim, and once the bank is the victim, it should not be made to suffer, right? It is compulsory for the adjudicating authority to issue notice on all those who may have a claim. So even if you have a mortgage on it, the adjudicating authority has to issue you a notice with respect to adjudication to show a show cause notice to you to show cause as to why the attachment should not be confirmed. Again, this answers the question. Property is acquired prior to commission of scheduled offense and mortgage to banks, and also mortgage to banks prior to commission of such scheduled offense could not be by any stretch be considered as proceeds of crime in the hands of the mortgagee bank. When monies are siphoned off from a bank holding public company, the bank is the victim and cannot be made to suffer. Even if the manager is accused of wrongdoing, the bank is not the manager and is the victim. I seem to have gone directly to thank you without any conclusion. But let me look up, questions, and I will be able to perhaps, go further into detail with regards to these and cover up more issues. What is the? I will start out in the chat. I'm sure a lot of people will be able to read with me. What is the conviction rate? I don't know, but according to Rajya Sabha proceedings recently, they're quite low. How has it curbed drug trafficking and arms trafficking? I think PMLA has moved way beyond that. In the Indian context, I think it is extremely relevant with respect to, again, as I said, siphoning off of money and Prevention of Corruption Act. Is an advocate required under PMLA to breach client confidentiality? Oh, yes, I forgot the case studies. I knew I had more. Let me just get to the case studies. I think they will be able to answer a few more questions with respect to advocates, right? Madras High Court, Nalini Chidambaram versus Directorate of Enforcement. This is reported at 2018 SEC Online Madras 5924. Summons under Section 52 were issued on a senior advocate seeking evidence upon some matters to do with her client. The senior advocate appeared through a pleader and sought protection granted to women under Section 160 of the CRPC, which says that that if it is a lady or a minor, then they need not go to police station. The police should come to them for recording evidence. The division bench of the High Court dismissed her appeal. Technically, they dismissed both appeals. There were two appeals. They, however, did not go into the scope and applicability of sections 126 to 129 of the Indian Evidence Act, because they said that they will be entering into a realm of speculation. Now, what is interesting is that the issue of a notice under 52, when it was given, obviously specific question, she was asked to present herself before the ED, but it would be highly speculative at that point to say what questions would be asked. So perhaps if questions that are conferred protection under Section 126 to 129 of the Indian Evidence Act, obviously those you could claim privilege for, but the High Court refused to get into that issue at that time, and they granted liberty to ED to issue fresh summons to require the appearance of the senior advocate in person. No, but getting back to the question, sorry, I'd gone ahead of myself. According to me, privilege can be claimed by the lawyers when it comes to certain sort of communication. There are exceptions that are listed out in Section 126 to 129, and there are certain caveats that are put in. Subject to those caveats, those protections will stay. But I do not know whether these would be necessarily, it would be debatable to see whether this would be true in case of in-house counsels that are on the payroll of a company. Vinod Kumar Gupta versus Joint Directorate. This is with respect to the appellate tribunal, which held that all professionals such as advocates, solicitors, consultants, chartered accountants, doctors, surgeons receive their professional charges from respective clients against services provided. Neither can the presumption under Section 51A be drawn ipso facto that they have the proceeds of crime received as professional charges in their possession, nor on the basis of presumption can their movable and immovable properties be attached unless a link and nexus directly or indirectly towards the accused or the crime is established within the meaning of Section 21U of the Act. In the absence of such a link, the professionals are to be treated as innocent persons, as unless link and nexus and proceeds of crime is established under Section 21U, the proceedings under the Act cannot be initiated. Thirdly, Axis Bank. This with respect to RPs, resolution professional appointed under the Insolvency Code does not have any personal stake. He only represents the interests of the creditors, the committee having appointed him, and he is tasked with him with certain responsibility under the said law. So if you are an RP or you are a law firm and your client is an RP and you are appearing for the company, and the RP receives the notice under Section 50 and some data has to be given, the RP can do so on behalf of the company, because for all intents and purposes he represents the interest of the creditor. Sorry, not as the RP, but he will be able to do so if he is the liquidator. My bad. With respect to a resolution professional, obviously the scope is a lot more limited. Yes, this is the case that people seem to be putting a lot in their chats. They say, when for issuing certain certificates, a chartered accountant is not required to go into genuineness or otherwise of documents submitted by his clients. He cannot be prosecuted for granting the certificate based on the documents furnished by the clients. The court observed that this could be compared with the legal opinion that are normally given by panel lawyers of banks after scrutinizing title documents without going into the genuinity. A panel advocate who has no means to go into the genuinity of title deeds and who gives an opinion based on such title deeds cannot be prosecuted along with principal offender. Now, the question that would this change when the professional is required to certify the authenticity of the documents but fails to do so? So it's one thing that it is just an issue of a certificate of remittances, etc., where data is given to you by the client. But what if you are certifying to a certain degree, at least, that these accounts or this certificate or these things have been verified by me, and due diligence is supposed to be exercised by me, then things become a bit murky, but I think they do not really wish to prosecute professionals unless a live link or a nexus can be shown between the crime as well as the professional. If you are a professional who has done actions in a bona fide manner, I do not think you have anything to be worried about. However, the onus will be up to prove your bona fides will be up to you, right? In Delhi, the court observed that an order of attachment, when made under the Act, does not result in the corporate debtor or a resolution professional facing a fait accompli. The statutes provide adequate means and avenues for redressal of claims and grievances. It could be open to a resolution professional to approach the competent authorities under the Act for such reliefs in respect of tainted properties as may be legally permissible. A provisional attachment order made by the enforcement directorate under the Act does not invest in that authority a superior or overriding right in the property. Ultimately, the claims of the parties or the property that may be attached and question of distribution would have to be settled independently and in accordance with law. So this is with respect to the RP or the RP who represent the corporate debtor or the liquidator, that when an order of attachment is made on the Act, that doesn't mean that he no longer has any assets to distribute, but then they would have to go under Section 8 proceedings and justify before the justify before the adjudicating authority that such assets are either not proceeds of crime or they are entitled to it because they have the right as mortgagees or secured creditors, and then the priorities would have to be established as per the operation of law. One second. Let's go up. Sorry. So confidentiality. Is a CA equipped to detect money laundering in course of normal etc. In course of bank and statutory audit, I'm reading questions. Sorry, I forgot to inform you all. In course of bank statutory audit, I find that bank branches fail to report suspicious transaction. Branches focus on KYC, despite that fake accounts do get opened and frauds take pay from news. Okay, I think these are different questions. Is a CA equipped to detect money laundering in course of normal activity? A CA is supposed to do what is required of him by the law, especially an auditor. I'm assuming when you're talking about CA, talking about auditor. PMLA cannot be initiated by a CA or a lawyer or by a normal person. The only person who decides whether PMLA proceedings need to be taken out or not is the Directorate of Enforcement. You and I do not get a say on it. So is a CA equipped to detect money laundering? I do not know, but you will be called upon if required by the ED or by the prosecution or by the defense to give evidence with regards to the certificates that you may have given or the audited balance sheets that you may have signed as auditor. So there is no escaping it. As professionals now, our roles have increased a lot. The means of these economic offenses have become more and more sophisticated. So, it touches us in ways that we don't even think possible. In course of bank statutory audit, I find that bank branches fail to report suspicious transactions. See, again, this is in the realm of FIU. IND, if if they do not comply with the requirements of the act, a fine will be put on them. Again, with respect to prosecutions or attachment, if a bank's property is if a bank is held to be in cahoots with the person, very often, again, as I've said, the courts seem to take the view that it is not the banks, but the people in the bank that may be actually to be prosecuted because they are involved in whatever misdeeds that may have been done and not the bank itself. So they have segregated the two and consider them separate entities. Newspaper reports is largely being used in politically motivated investigation, very often in Prevention of Corruption Act, yes, but that is in the realm of speculation for most of us because whatever the newspaper report they may report, the thing obviously comes down to whether the ED takes any action or not, and of course the ED gets the say on whom to prosecute and whom not to. Yes, this act is largely being used to arm twist CAs to give evidence against the client under investigated by PMLA, else they themselves will be arrested. Okay, I will say that I do not think this act is being used to arm twist CAs to give evidence against their clients because if your clients have done wrong and if they have to be prosecuted and if you have obviously signed a balance sheet saying a certain thing, or if you're privy to some information that they have done wrong, then you do not qualify for privilege under the Evidence Act when it comes to 126 to 129. So you will obviously, when called upon to give evidence, you will have to be called upon to do so. It is not this act. It could be also for any other act. It could be for a check bouncing case. It could be for any economic offenses. CAs also are now being called in to give evidence with respect to SFIO. They could be called in with respect to, giving evidence under Benami Act. As CAs have a lot of access to their clients and their books of accounts. So you should not be surprised that they're called up to give evidence against the client or for their client. By expanding the list of scheduled offenses, have they not diverted from the main object of art to target I'm assuming black money because written red money. There is a judgment that says that if I have cash deposits in my bank account, PMLA cannot be invoked against me. That is for income tax to take whatever action they want to. PMLA Act is not to curb black money. PMLA Act is to take away the rewards for committing scheduled offenses. Let us not mix those concepts. With all due respect, the black money is different, and I do not know what red money is. Is it drug money? I do not know. If Manoj Gupta ji is here, can he please rephrase the question? But yes, by expanding a list of scheduled offenses, they seem to have diverted from the main object of the act. But the point is, it is a policy decision, right? The Supreme Court's already held. It's a policy decision. They may decide, that tomorrow, what if they hold that all criminal acts will be scheduled? What if they, put all the criminal acts as scheduled? What if they put offenses under Income Tax Act as scheduled offenses? It's the call of the government, the call of the, sorry, not of the government, of the legislature. So I do not think we get much of a say. The act has already moved on from trying to target only drug money or, arms trafficking or drug. Sorry. The Madras High Court once CAs cannot be held responsible for verifying genuineness of documents provided he is in compliance with audit, so has adequate documents to prove it. I've already discussed the Madras High Court judgment in short. If more explanations required, you all can tell me. Yes, Manoj Gupta ji has answered, not for audit. Again, as I said, with respect to audit, even I have my doubts. That could be interesting because though there are caveats and, the age-old saying that an auditor is not a bloodhound, he's a guard dog, that the saying. But we still have to certify that these give, at least fairly based on the information given to you, a fair and true view of the financial position of the company. Do independent directors enjoy immunity against PMLA? I do not think there is any role for directors, independent directors, etc. against PMLA. All the scheduled offense, see, it depends upon the scheduled offense. What you do as an independent director or what you do as a member of the board, it all depends. See, because finally what is being prosecuted is you, right? Now when you are looking at most of the scheduled offenses, most of them, the offenses are with respect to individual that perpetrated, but it is always up to you to show that you are not in. If a company has committed an offense, the burden will be on you to prove that you had nothing to do with it. You are an independent director, and not only were you an independent director, that you were truly and actually independent and not taking part in the management of the company. The circular of October, this thing I said SEBI, but there are RBI norms too. More can be given later. Pleader can be lawyer only. Pleader cannot be CA because, well, pleader is very specifically with respect to someone who goes to, I'd like to believe, a judicial or a quasi-judicial, someone engaged as a pleader to plead the case before the person. So it could be lawyer, it could be CA, but I do not think that privilege with respect to what you are saying, what you are planning to prepare in front of judicial or quasi-judicial authority is what the ED is actually interested in. According to me, they are more interested in what, how you're structuring transactions, what transactions have actually happened, what documents have you gone into, what documents have you seen, etc. In these cases, is defamation possible? If Shweta Ajmera ji is still there, I'd request her to kindly give a more detailed question. Are we talking about defamation case against the ED? So please do let me know. If you all are still here, please put the questions in, right? Please differentiate between IPC and CRPC. I've already done it. What is the difference between reasons to believe and reason to suspect? Okay, that is fine. That is with respect to 148 of the Act, but reasons to believe stands on a stronger footing than reason to suspect. There are a lot of judgments out here. I think even the Delhi High Court judgment that I may have referred to specifies very clearly that reasons to believe are on a stronger footing than reasons to suspect. However, most of the actions on Section 5, Section 8 require reasons to believe and not reasons to just suspect. But I could always check the rest of the sections out right now on the fly so that nothing is left for later. Just 1 second. Right. So when we are talking about Section 5, let's see Section 5 because I've already brought it out. Section 5 is when the person, the deputy director, has reasons to believe. Section 8 also says reasons to believe. So reasons to suspect, I do not think is very important out here. Reasons to believe, again, Section 8. Let's go to 16 and 17. Right. Search of persons is Section 18. Again, Section 18(1) says reason to believe for search of person. Power to arrest. Power to arrest, Section 19(1), again, reasons to believe, not reasons to suspect. Search and seizure under Section 17, is again reason to believe, not reason to suspect. Power to survey, section 16. Again, reasons to believe. Because PMLA is such a strong act, I think reason to suspect would anyways be too lower threshold. So reasons to believe is the gold standard when it comes to initiating proceedings under the sections that I've just said. Can additional evidence be submitted at adjudication stage? There is no call for additional evidence at adjudicational stage, because the first place where you get to defend yourself is the adjudication stage. So you will be able to give evidence at the adjudication stage. There is no IO in this. The provisional attachment is done by the ED. They may do it without issuing any notice to you. So at the stage of evidence, at the stage of adjudication, notices under section 8.1 will be issued to you, and you can reply to it with whatever evidence you need. And if you want to file more additional evidence, that would be at the stage of the tribunal, not at the stage of obviously the adjudication. Can the property that was acquired before commission of scheduled offense be attached? I've said technically it cannot be attached, but if the proceeds of crime sought to be attached are falling short of the amount of the actual proceeds of crime, then there is a chance that the ED tries to attach property acquired before commission of the scheduled offense as value equivalent. What is the case if only the property the accused has is ancestral? The answer would still remain same. If it is his property, then it could be attached as value equivalent. If at all it is joint owned by the family, then under section 8.1 notices will have to be sent to everyone who has an interest in the family, in the property. Sorry. Let me just take you all to section 8.1, because I think reading section 8.1 will be of great help with respect to the attachment questions. Section 8. Right, section 8 says that on receipt of a complaint is fine. So when it says that there is a second proviso to section 8.1 that you may take a note of, it says that provided further that when a property is jointly held by more than one person, such notice shall be served to all persons holding the property. And the first proviso says when a notice issued specifies any property as being held by a person on behalf of any other person, a copy of such notice shall also be served upon such other person. Secondly, the 8.2 says the adjudicating authority shall, after considering the reply and hearing the aggrieved person and taking into account all the relevant materials, by order record a finding whether all or any of the properties attached are involved in money laundering. And this says that if the property is claimed by a person other than a person to whom notice has been issued, such person shall also be given an opportunity of being heard to prove that the property is not involved in money laundering. I think that answers that question. So even an ancestral house doesn't matter. It can be attached as value equivalent, cannot be attached directly as proceeds of crime. Everyone who has this thing, what do you call it, who holds it or who has an interest in it will have to be issued notice. And if you haven't received the notice, you can still go before the adjudicating authority and say that you have not been this thing. Thank you, Sanjeev Goelji, for your compliment. Rajesh Irshad ji, is there any time period to take action about 10 years and about 10 years can't take action? I do not think that there is any specific time period about this thing, because they have said that the act of money laundering is a continuous activity. So if you all see the definition of offense of money laundering, we have already been to it. It's a continuous activity. So the scheduled offense may have happened earlier, but as long as the money is being enjoyed by the person. So I will take you all to section 3, explanation Roman 2. The process or activity connected with proceeds of crime is a continuing activity and continues till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use or projecting it as untainted property or claiming it as untainted property in any manner whatsoever. This takes out any scope we had of putting limitation of 10 years on it. Red money is money derived from crime. Thank you, Manoj Gupta ji, for giving that clarification. I hope my answer has already clarified it. Can the offense of money laundering be given retrospective effect? There is a lot that goes into retrospective effect, because technically you'll have to figure out what are you talking about. Retrospective effect in the way that before 2002, you'll have to look at whether you're talking about before it was introduced in the schedule. There are a lot of questions with regards to this. And very honestly, a lot of it is answered in my book. Sorry for the selfless self-promotion. But their criminal law cannot be given a retrospective effect. But again, what happens is the process or the activity is a continuing activity. So section 3 explanation 2 again to the rescue of the to the this thing, sorry, directorate. Can an investigation be based on a schedule offense before introduction of PMLA? Technically, it cannot. But the question is, again, if we say it's a continuing activity, then the ED has a case for reopening it. Can a CA give a disqualification, disclaimer or qualification or an adverse opinion? Can CA plead before a tribunal? I do not. I have not seen the. I have not gone in depth to the rules, but I have not seen the rules. What they say about a CA appearing before the PMLA tribunal. I apologize. That is something that I will have to get back to you all on after looking at the rules. But usually, I believe PMLA tribunal. I have seen advocates appear more than CAs. But the rules will have to be consulted. I'm sorry I couldn't give that right off the bat. Can a CA give a disclaimer or qualification or adverse opinion with respect to what? Again, that is the issue. A disclaimer or qualification or adverse opinion with regards to what? Are we giving a disclaimer saying that I have done it based on the documents given to me? Sure, I can do it. But if you're putting in a qualification in an audit report, I don't think the client will appreciate it. I mean, unless you have very strong reasons to believe that there is some hanky-panky that is being done, right? Will a innocent misdeclaration in RBI forms to AD consist cheating under 422 and create a money laundering case? Sir, this has to be gauged on the merits, because 420 IPC cheating is very specific, right? Section 420 of the IPC is a crime by itself. So it says cheating and dishonestly inducing delivery of property. Whoever cheats and therefore dishonestly induces the person to be deceived or deliver any property to any person, or to make, alter, destroy the whole or any part of valuable security, or give anything which is signed or sealed and which is capable of being converted into valuable security, shall be punished with imprisonment of either description of a term which may extend to 7 years, and shall also be liable to fine. The question is whether a innocent misdeclaration of RBI forms constitute cheating under 420 only. So the money laundering case, again, depends upon whether it would constitute cheating under 420. Yes. Sorry. Mr. Arun Naik is asking, what if no property or bank balance with the accused? Then they will have nothing to attach, but they will still prosecute. What if the proceeds of crime has been lost or consumed and accused has no other property? I would request whoever's Shiv Kedia ji not to, because I get confused between 3 different things. So there should be some way to differentiate them. But let me answer this. What if the proceeds of crime have been lost or consumed? Then they will go down the chain and they will see whether the person whom you have transferred that property to is bona fide or not. If that person is bona fide, then obviously, it stops there and they will try to recover it from you in any way possible. But they will anyways charge you and then convict you for money laundering if required, based on the evidence, if you have no other property. If not, they will attach value this thing. Statutory audit or certificate, sir, I will not be able to tell you right now whether you will enjoy as a CA immunity with respect to a statutory audit. A lot of it would be determined based on what the ED brings your role out to be, right? Like you have a lot of scams in which partners of CA firms are actively accused in what has happened. Now, if you have been made an accused in a scheduled offense, and if PMLA proceedings are taken out against the promoters of the company, then there's a very good chance that you will probably be accused of PMLA also. So it's a very broad statement, but everything would determine based on the facts of the case. Even the Madras High Court judgment has to be taken in that light. They were looking at they have been very categorical as to the certificate that was issued, as to what are the requirements behind the certificates, and then said that this certificate has to be issued only on the data that is received on the client. Therefore, we are saying that, obviously, no charge of PMLA. Right. Whether defamation claim can be filed against ED as a person having reputation, I will go one step forward. if you have been wrongly prosecuted under the PMLA, and if there has been abuse of process of law, if what has been done is not a bona fide action against you, action can be taken against the ED officers, which is one of the most important aspects that they considered, that Vijay Madanlal Chaudhary considers when they give the judgment, saying that the officers are accountable. They can be prosecuted themselves. Action can be taken, not prosecute, sorry, action can be taken against them if they have abused the provisions of law. Defamation claim can be filed against the ED. Again, defamation is also of two types. There's civil defamation and there's criminal defamation. The idea is, of course, before you file a defamation suit against the ED, obviously you may want to, have established that you are not guilty of that crime. You establish that you're not guilty of the crime. No one's saying that you're guilty of the crime. What if we followed the guidance note of ICA in course of a professional duty and are well documented? There is absolutely no difficulty about documentation. And with respect to guidance note of ICAI, you cannot be prosecuted if you're innocent. No one is saying that only based on a certificate you will be prosecuted for PMLA. For PMLA, there needs to be a live nexus with the money laundering activity. There has to be, you have to fall within the definition of PMLA. So if it is shown that, we are all aware there are, when I was doing my articleship, it was very famous. It was said that a lot of people were, some small time CAs were signing balance sheets without properly verifying the books of accounts for small companies. It was also seen recently, it was there certain advocates blindly verify, or some notaries sign in absence. Now obviously that puts a different complexion on things, that changes everything, right? But that would again be on the specific facts of the case. What has the CA done? What has the advocate done? What is the document? What have they said? Whether there is a qualification, whether a qualification was required, can you justify the lack of qualification? All these aspects again need to be considered. Can the accused get a stay on trial by media? We've moved beyond PMLA Act, but I'm sure that if anyone wants to try getting a stay on trial by media, I'll be happy to try on their behalf. Very few people get to get a stay, a gag order on the freedom of press, especially when it is done. So freedom of press is a fundamental right in a country. Well, I think I've rambled enough with